On day one, I will pick a new head of the Securities and Exchange Commission and remove Gary Gensler. To be honest, I had no idea that you were so controversial. I will repeat it once more. Nominate a new chairman of the Securities and Exchange Commission who is of the opinion that the United States ought to develop the future rather than stop the future, which is exactly what they are doing. Also, Kamala Harris is interested in making him the Secretary of the Treasury. It's not a good sign. For Hillary Clinton, he served as her financial person. Aware of that, were you? That. Crooked Hillary. Have you heard of Crooked Hillary? Is she still in your memory? Are you able to recall? In the campaign that Hillary Clinton ran against the individual known as Donald Trump, he served as the chairman of the Finance Committee. On Saturday, Donald Trump, who is now the leading candidate for the Republican Party in the United States, delivered a speech in support of cryptocurrencies at Bitcoin 2024. During this address, Trump was attempting to win over the voters who advocate for Bitcoin. The anti-crypto position that Kamala Harris has was a warning from him. His discussion was on putting an end to the anti-crypto jihad that the Democrats have been on the offensive. First thing in the morning, President Trump announced that he will be firing Gary Gensler. It would be advantageous for the Bitcoin market as a whole to have this development. It is our intention to put an end to Gary Gensler's rule of control through enforcement if he continues to serve as chair of the Securities and Exchange Commission. Election polls for the presidency of the United States candidates. As of right now, the most recent national polls indicate Donald Trump is currently holding a slight advantage against Kamala Harris during this election. The Fabrizio Lee Associates to JK poll, which consists of two polls that were carried out between July 23rd and July 25th, is sponsored by the Wall Street Journal. The poll was conducted between July 23rd and July 25th. The results of one poll indicate that Trump is leading by 2 points, while the results of the second poll indicate that Harris is leading by 1 point. Due to the fact that there was a lack of certainty regarding the conclusion of the contest for the presidency of the United States, the influence of Trump's pledges on XRP was limited. A decision regarding the case that Ripple and the Securities and Exchange Commission (SEC) have filed will be made public well in advance of the presidential election in the United States. As of Saturday, the likelihood of a settlement being reached in the Ripple case, brought by the SEC, became less likely. On July 17th, XRP achieved a high of 63 cents before sliding back below 60 cents. This development came about as a result of speculation that Ripple would be present in a closed meeting of the Securities and Exchange Commission that was scheduled to take place on Thursday, July 25th. Ripple and the SEC have remained silent ever since the CLC went forward with its meeting that was held behind closed doors. There is no information that has been revealed by either party on whether or not negotiations for a settlement are currently taking place. The penalty that Ripple is forced to pay for violating securities laws will be determined by the courts. The event that Ripple and the CC are unable to negotiate a settlement. A decision on the SEC versus Ripple case is anticipated to be handed down in the near future. A decision about the matter is currently being deliberated upon by Judge Analisa Torres, who may announce her verdict at any time. Ripple was found to have breached US securities regulations in July of 2023, according to a verdict that was handed down by Judge Torres. The ruling stated that Ripple had sold unregistered XRP to institutional investors. With the filing of the allegations by the SEC in December 2020, with the filing of the complaint, it is the responsibility of Judge Torres to determine whether or not Ripple continued to violate the laws that govern securities in the United States. During the process of determining whether or not an injunction is necessary and reasonable, the Securities and Exchange Commission (CC) makes a credible argument that the district judge may take into consideration the activity that took place after the complaint was filed. This verdict was handed down by Judge Sarah Netburn in February of 2024. The Securities and Exchange Commission (SEC) presented its opening brief discussing remedies, in which it argued that Ripple continues to violate a securities law. The arguments that took place between Ripple and the SEC after the complaint was filed were presented by the SEC. During the course of the legal proceedings, the Securities and Exchange Commission (SEC) made a request for an injunction that would limit the sale of XRP to institutional investors in the United States. Ripple, on the other hand, presented their opposing brief proposing remedies in April of 2024. In this brief, Ripple defended its post-complaint action. According to Ripple's reasoning, post-complaint activity was in compliance with regulatory requirements imposed by the United States Securities and Exchange Commission. According to the business, XRP sales were made through on-demand liquidity, old agreements that make it hard for investors to make a profit or lose money, or to accredited investors who are exempt from restrictions imposed by the United States Securities and Exchange Commission that govern securities transactions. There are essential standards that must be adhered to in order to comply with ODL agreements. When ODL agreements restrict gains or losses, the Securities and Exchange Commission is unable to assert that investors can anticipate profits from the sale of XRP under those arrangements on the PLI. Grounds that the agreements prevent gains or losses. In the event that there is no assurance that the company will realize a profit, the third component of the Howey test is not satisfied. As the third component of the Howey test, the anticipation of receiving financial gain through the efforts of other people should be taken into consideration. Ripple was not accused of being reckless or dishonest simply because the Securities and Exchange Commission did not make the accusation. In addition, the corporation suggested a fine of $10 million for the violation of a Securities Administration regulation. In the event that the litigation is resolved, the demand for XRP will be impacted. In the event that the SEC files a report on the matter, the decision on the programmatic sales of XRP would have a significant impact on the demand for the cryptocurrency. In August of 2023, the Securities and Exchange Commission (SEC) presented a motion for interlocutory appeal, in which it asked the courts for permission to challenge the ruling regarding programmatic sales. As a result of Judge Torres's decision in October 2023 to reject the motion for interlocutory appeal, the Securities and Exchange Commission was required to wait until the final ruling before taking any action. Since the verdict in October, the Securities and Exchange Commission (SEC) has sped up the Ripple case by withdrawing the claims against Chris Larsen, the co-founder of Ripple, and Brad Garlinghouse, the CEO of the SEC. This has allowed the proceeding to move forward more quickly. During the time that it is considering its petition for interlocutory appeal, the Securities and Exchange Commission (SEC) may submit an appeal against the ruling concerning the programmatic sales of XRP. The Securities and Exchange Commission would no longer be able to file an appeal if the parties reached a settlement. Bill Morgan, an attorney who advocates for Bitcoin, explained his thoughts on settlements in the following manner. In general, the employment of settlements is the method that is utilized to resolve issues that are in dispute, including appellate rights in instances that are currently being litigated. The SEC and Ripple are not likely to come to an agreement over a settlement, according to Morgan. Recent statements made by him indicate that this is not likely to take place, but in the event that it does, it will be a compromise rather than a huge win. It is an indication that both parties are willing to make concessions in some specific area. Judge Annalisa Torres is the one who is in charge of making the decision on the penalty that Ripple is forced to pay for selling unregistered XRP to institutional investors. As a result of the Securities and Exchange Commission CLS's determination to seek a penalty and injunction in the amount of $2 billion, the punishment will pique the interest of investors. If an order were to be issued that forbade the selling of XRP to institutional investors, it may potentially have an impact on the company's plans to expand in the United States. Must Judge Torres allow the petition? It is possible that XRP may be subjected to severe selling pressure as a result of SEC's request for an injunction. It is important to note that if an injunction is granted, the Securities and Exchange Commission (SEC) may be encouraged to launch an appeal against the ruling regarding the programmatic sales of XRP. According to the decision that Judge Annalisa Torres made in July 2023, programmatic sales of XRP do not in any way satisfy the requirements of the third prong of the Howey test to any degree. Recent court decisions that were related to the SEC versus cryptocurrency litigation have generated worries about whether or not the Securities and Exchange Commission intends to appeal the decision involving the programmatic sales of XRP. The SEC has been criticized for its intention to challenge the programmatic sales ruling. In December of 2023, Judge Jed Rakoff came to the conclusion that Terraform Labs and Duquan had broken the regulations that govern securities in the United States. This was due to the fact that Torres and Luna were not registered as securities.